So let me introduce Yvette Valencia.
Good morning, everyone. Today I have an interesting topic. It is about probate, but how much does death cost? And why is this important to you guys? You guys are purveyors of dreams. When people come to you, they most likely say, they don't say, I want a house. It's, I want my home, my first home, my second or third. You guys make American dreams happen. And one of those biggest dreams is to own your very own home. So what is probate, and why would this be important to you? One of the other things you guys are is you're everything. You're counselors. Once a person purchases a home, where do I get a good insurance, a nice plumber, a contractor? Your clients go to you. You guys are a one-stop everything. So one of the things that you're doing is a person acquires a home, their dream home. How do we protect it? We protect it by having the correct legal documents, and we do not want to go to court. We do our laundry at home. We take care of everything at home. We don't want to go outside. So why, when we pass away, when we get sick, incapacitated, why do we have to have a third party, a judge, go to court to make our family decisions? So probate, how much does death cost? I have an example. There's a correction, and I'll get to it when we get there. But probate is a process. When people divorce, you go to family law court. If there's something criminal, you go to criminal law court. Civil, something with money, you go to civil court. Probate is a court where you go when you pass away with a will or without a will. A will is a letter of wishes that has to be approved by a judge. A conservatorship or a guardianship, you go to probate court. What's that? Well, many of us, if we're married, and we've been married 40 years, even if we're married and we hold, let's say, our home as joint tenants, Mary and Bob Smith, as husband and wife as joint tenants. Bob gets sick with cancer. Mary wants to refinance to get some special treatment. Can she do it? If Bob can't sign? No. What do you have to do? Go to court. Why? Because you don't have a power of attorney. Probate court that's where you do it. You go get a conservatorship. Now you're asking for not only financial power of attorney. You were driving down to San Diego when this happened, and you're here from San Gabriel. You need to get Bob back from San Diego to San Gabriel. And you don't have a medical power of attorney. Can somebody stop you? Yeah. Where's your power of attorney? Where do you go? Court. Why? You say, Your Honor, my husband's sick. I need to make medical and financial decisions over him. Huh? How much does it cost? $10,000 to start. What do you need? The correct legal documents. So probate, it's going to all tie in. So when you pass away with a will or without a will, you go to probate court. If you need a conservatorship, you go to probate court. My example in front of you is for a home with no equity. Where 2005, this family home was costing $600,000. Could have sold for that. Then it's 2007, market goes down. 2005, the family pulled $300,000, remodeled the whole home. And now it's 2008, and the home is worth $300,000, and it has no equity. Parents die, kids want to keep it. And you're like, what? It has no equity. This was our family home. It's newly remodeled. We'll know the market's going to go up, and we want to keep our home. Parents left no will. What do? We go to court to try to fight for our family home. So this example is $300,000 residence with no equity. That's the reason why we're going to court. In LA County, to start a petition, it's $465 just to start. If we need to make a change, $465 for an amendment. For a final account, it's $465. That final account might come in 2-3 years later now. And it's a $200 status report per year. Why? In 2013, with all the budget cuts, we had about 9 probate courts in LA County. We now have 2. We have downtown LA and Lancaster. That's it. So if I had a client, dad passes away, leaves one son, maybe I could most likely finish in just under a year. Now, no. I put in for my final report. I used to give it in, let's say in January. By February, maybe early March, I would have a date. Now they're setting those hearings 5 months out. It's taking a lot of time. So what else happens? So the first thing in court is petition. So it's probate and then the petition. Anything in probate is public. The P stands for public and probate. The next thing is publication. We might come into cultural obstacles, and they're like, clients might say, I don't need anything. Why don't I need anything? When I pass away, I don't need anything. I'm not going to feel it. I'm not going to see it. Let them fight. When you pass away, with a will or without a will, and owning a home with no equity, you die with your deed. Your kids can't change the property. You can't do anything unless you have some documents. So one of the things that you have to do is publish. Attorney Yvette Valencia passed away. She left the house. Does she owe anybody? Please come get. If we have any equity, if we have any life insurance, anything else, come get. That's what the publication is for. It's to notice creditors. After publication, a bond. So we have Bob and Mary Smith passed away, leaving one child. And the child tells the judge, Your Honor, I'm the only beneficiary. Can you please allow me to do this without a bond? The judge looks at Bob Jr. and says, no, I don't like you. We're going to have you place a bond. He's the only beneficiary. Judges can do anything. And it's not uncommon. It's just you have a person at the bench trying to make the best decision, and we have to make judgments. And it doesn't mean that they don't like you. It's just judgment. So part of it, now the bond. So we have a house with no equity, $300,000. The bond is on $300,000. That's $1,300 per year. If our probate lasts 3 to 5 years, every year, $1,300, $1,300. You get the money back? No, it's lost forever. After that, we have a probate referee. A probate referee is an individual that is appointed by the judge, and that probate referee goes and checks out the house. For a $300,000 home and nothing else, it's usually a little bit over, just about $300 is what we pay, and it's a one-time fee. Now, statutory fees. How much do attorneys earn? This isn't, come on, give me a deal. This is a statutory guideline. And this is where the error was. But for $1 million property, what it is, and it's on the value, not on the equity. So on a $300,000 home, the attorney gets paid 4% of the first $100,000, $4,000, 3% of the next $100,000, $3,000, and this is where we did a little error, but 2% of the next $100,000 is $2,000, and I think the document you have in front of you says $1,000. So the attorney gets paid $9,000 minimum. The administrator, the executor, well, if it's Bob Jr. and he doesn't have anybody else, he's going to waive his fees. But now we have Sharon, his sister, long-lost sister on the dad's side. She comes in, and now he's like, you know what? I got extra work. I don't want to share my inheritance. I'm going to get paid $9,000 too. They start fighting. That's where the attorney says minimum, because now I have kids fighting, and I can charge my hourly rate $300 or up, depending. I have colleagues that charge $600, $700 an hour. Your money, your inheritance goes away. I always recommend to my clients and to their children, do not fight. Right now, when part of the probate process, if one of the things that you do is you go to a mediator. Usually parties hire private mediators to make sure that we can get things done quicker. A private mediator is usually a retired judge with a lot of experience. And how much does he charge? $500 an hour. Well, that's pretty good. We can get this done in 2 hours. Yeah, but you have to block out a 10-hour period of time. So in one day, we have a judge. We pay $5,000. Each side has to prepare a mediation brief. Another 10 hours, $3,000 per attorney. Now we have to go present the mediation brief in front of the mediator, and that's going to take 10 hours. So in 1 day, 2 days, you've spent $30,000 by not having the proper documentation. So How much does probate cost? It costs a lot. If you were to ask me, what does peace of mind cost? It's priceless. I can't tell you, I'd love to sleep at night. I love to not think of anything else. Peace of mind is priceless. What can you do? What can you do to avoid probate? You can have trusts prepared. A trust is a family contract. That's what it is. Usually they can be changed upon agreement. A trust, as opposed to a will, which is it's a letter of wishes that has to be approved by a judge. A trust is a family contract. It's like hiring a plumber. He charges us $1,000, $500 to start, $500 to finish. He does a good job, we pay, and you put the contract to the side. If Bob and Mary passed away, they had a trust. It says everything goes to Bob Jr. What does Bob Jr. have to do? He can see an attorney, and in less than an hour, once you get the death certificate, they review the documents. In less than an hour, an attorney can prepare the deed transferring the property from Mary and Bob to Bob Jr. for $300 an hour. And it's all done. So as realtors, and you guys are the go-to people, one of the things that you can leave another of the gifts that you can leave your clients, not just the American dream, but a comment. Make sure you guys have your trust. You have your assets. Have good insurance. Don't only pick the cheapest one. It's the one that'll help us. Have life insurance. If you have kids, make sure that your insurance adequately covers the mortgage. So if something does happen, your kids, your family, your wife, your husband, they're prepared with everything that they need. Have a trust. Have powers of attorney. Have everything drafted to protect this family dream, protect your family home, to make sure that your next generation, grandkids, they can also enjoy all the hard work. So we don't have to keep starting at zero.
Questions?
Any questions? Yes.
How about insurance? Do you say we should put insurance policy inside the trust or not?
It depends. Everything depends on the situation. A trust, again, is a family contract. And you can say, oh, I have a normal family. There's nothing normal. Every family is unique. Every family has different needs. Every family has from different tax situations to minors. I have 2 small kids. My 2 small kids, I have my insurance going directly to my trust right now. Why? Because if I pass away and my husband has passed away before me, that insurance, my insurance company gets to keep their money until they turn 18. At 18, they each get $1 million, they blow it on a car, and that's it. So what would I do? I make sure that my insurance goes into my trust. I have somebody responsible, my trustee, my mom, my brother, my aunt, to be able to administer for my kids until they're 21, 18, 25, they've graduated from college. You can tailor your family agreement, your trust, to avoid court, but so it's not yes or no, it depends. Now let's say I'm in a really high tax bracket. Maybe I want my insurance to be right out of my trust. There's different reasons why we do different things, and it depends. Very good question. Yes?
This may seem a little abstract, but if a person owns a property on the sole title, and they give somebody the power of attorney, and then they pass away, is that invalidated with power of attorney?
The power of attorney is done as soon as you pass away. Powers of attorney are, so if they did something right before you passed away and the notary book and everything, you might, but as soon as you pass away, the power of attorney ceases to be effective. A durable power of attorney is usually during a person's incapacity. And so if a person's sick or let's say they're out of town, there's different reasons, but at death, that power of attorney finishes, and that wouldn't help you at all. Anyone else? Yes?
So how does a will help versus a living trust? It says here that with or without a will.
With or without a will, you have to go to court. But a trust is a family contract. That's going to be your main document. When clients come to me, I also prepare a will, but it's a pour-over will. It's attached to the trust. So I purchased my first home 10 years ago. I purchased one today and I pass away tomorrow. I didn't include it in my trust. So now my husband, because I bought it as my sole and separate property, he has to go to court. But he says, Your Honor, we have a trust, or my wife had a trust, a sole and separate property trust, and her intention was to put it into the trust. She didn't. So in your example here, when you have a trust and you have a will, a pour over will, it allows you to pay the $465. It says, Your Honor, I have a trust. Let anything else that I have outside pour over into my family contract. How long does it last? If you can do it right, 2 months. $465 and a flat rate for whatever the attorney charges you. Yeah, very good question. Yes?
I have a question. If, let's say my parents, you're gonna want to put you on the deed, pass away, transfer 5 years, you still have to do it.
No, but this is when clients come, I can count on one hand how many times I've transferred between a parent and a child. I've done more transfers where children are trying to get back to their parents. Why? Parents now that are elderly, or just older, you have less risk. It just, you're not going to be driving crazy. You're not going to be doing stuff. You've been married 40 years or more. You transfer the property to your child. Your child gets a divorce. Even though it's separate property and the person who your child married, who's now a grown adult, they can be spiteful and try to get as much from that property just to be spiteful, not because they know anything's theirs. So that's one example. So if you put your kids on the deed, yeah, it simplifies everything, but their divorce, their lawsuits, all that is now subject to that property. You can leave the parents homeless. I had a client, my aunt calls me and says, Yvette, can you help my aunt? Or can you help my friend? And I said, yes. I shouldn't have said yes, but I said, yes, what can I do for her? She says, my friend works at the hospital, she's a widow, and she transferred her property to her only son. Makes sense. Her only son had just died in a motorcycle accident, and son's wife is kicking lady out. Can we do anything? No. The papers have to correctly identify. We, within ourselves, we still have an oral culture. Yes, we do write things down. Yes, we have smartphones. We have all this stuff, but we still have an oral culture. Our eldest son is going to take care of this. If you place the house or anything in the eldest son's name, does he have to share with his siblings? No. If he passes away, does it go to his wife? Yes. You left everybody out. But I know Johnny's going to do good. Johnny's not going to do good. So what we do is we try to protect and organize families to make sure that their wishes are done. You can do a deed. $100, it's not worth it. In the end, all our kids' liabilities, any debts, everything gets attached. Bankruptcy, and now our home is attached to theirs, to their liabilities or irresponsibilities. So it's best to get a family contract. That's why I said that all these families, no one's normal, everybody has special needs. Yes?
How about in the case where the owners own commercial properties?
Well, if you have a commercial property, depending the way you hold it, so if you're a sole proprietorship, you could just throw it into your trust. If it's under an LLC or corporation, you assign your LLC or your corporation to your trust. And it says, so it doesn't change the way you do taxes or anything else, but your trust is also, so I said a trust is a family contract. A trust can also be like a bank account. You keep putting in, you take out, you put in, you take out. So you have a bank account and then you have sub-bank accounts. So if you have an LLC, a corporation, you can start a DBA, you can tie in everything to your trust. Life insurance policies. Yes?
I'm not sure if you answered this before, but I'd like to get it. If some family member they have a trust, they set up a trust, but for one reason or another, they've never recorded the deed in the trust's name. So the title still shows it as a single-family residence in this person's property. That person dies. How does the trust have authority over the property if it's never?
Well, when you have a trust, there's several documents. You have powers of attorney, but you should also have a pour-over will. So that pour-over will allow you to say, Your Honor, we did the trust, we purchased the house before we did our trust, and it was our intent, for whatever reason, and it happens a lot, it wasn't placed in. $465 right now for the petition, a flat fee that the attorney charges, and it's in, and usually within 2 months.
If there's a portable.
Yeah, well, even if you didn't have a pour-over will, most trusts have language that says, please throw everything in. But the pour-over will helps a lot. Yes?
Good morning. Over here on the publication, you have LA City County, I assume it's LA County.
Yes.
And then it says San Bernardino. And I was just noticing that one of the cheapest counties in Southern California, you have to spend $3,000.
Let me tell you why they charge me by the letter. I asked. I'm like, in LA, so if you live in the city of LA, most places, I can even sometimes get publishing for $195. But depending on the county, so if you live in Whittier, that's incorporated in the county, that'll be $600. El Monte, $565. But San Bernardino and Riverside, for whatever reason, they charge me by the letter. So if you have a Latin name like Maria Dolores del Refugio Gonzalez, that price is not going to be $2,800. Because they'll write your name 10 times and they're charging me by the letter, and that'll be a $5,000 publication.
So Kawasaki, all the Japanese losing.
Joe Smith. Yeah, so that's the difference for publication. We have to publish. This is usually approximates of what the newspapers charge me. But yeah, Riverside and San Bernardino charge by the letter.
Now, since we're going electronically, is it still going to be a paper publication and an obsolete medium?
You know,
or could it be on Craigslist or something?
No, right now it has to be published even. So like if you're doing, these are newspapers that nobody even, it's just,
Look at it, yes.
they don't even look at. Nobody even, you know what, who does? You have credit, like bank companies and stuff, that the creditors are looking to see if any of their people have passed. There's actually people that go through the obituaries to see. But other than that, nobody looks at these newspapers. So the law says that it's to give notice, but nobody reads them.
But would it be even cheaper to use a service like CoreLogic or some of the title companies use it? I mean,
It has to be the process. I've had clients that say, just skip it. Well, the judge won't let us go to the next step if we don't show a little piece of paper that says that it was published and following whatever rules we have. Yeah.
Like the divorce thing, you know, you have to publish, you're getting divorced.
Yeah, so they're just rules. They might not apply anymore, but we have to follow them. Yeah, we have to follow them. Well,
Last question.
What about a situation that you have, actually it's a friend of mine, has a son and has a
common law wife?
wife and has a child. So in case something happened to the son, can the common law wife petition to get the property?
She can petition. It may not be granted. Here in California, we do not have common law marriage. It's a myth. So you can live with somebody 7 years or more. They don't get anything. It's a myth. There's no common law marriage. But when you guys get divorced, you go to family law court, right? If there's a person that's, let's say a wife, or a common law wife, she's at home and she's been there 20 years and raised the kids and everything. And all of a sudden, the husband wants to leave. And she's like, well, wait a minute. I just gave you 20 years of my life. We had 5 kids. Well, there isn't common law marriage here in California. What you do is you sue under contract. And so we had a contract. I'd stay home, take care of the kids. I've done this for 20 years. Something has to be mine. But you don't do a petition in family law court. You go to civil court because you're suing on contract. But that's something different. Well, thank you very much. It was a pleasure.